The Trump DOJ just made a move that could change how millions of gun owners think about pistol braces overnight. And if you hear only half the story, you could wrongly believe your braced pistol is safe when the government still thinks it might be an SBR. Quick question before we continue. Are you subscribed yet? Because updates like this can keep you from learning about a gun law change after you've already stepped into trouble. Hit that button now, because this one is confusing, fast-moving, and way more important than most people realize. Here's what just happened. A lot of people thought the fight over pistol braces was basically over. They heard the brace rule got smashed in court. They heard the new administration was reviewing it. They heard federal agencies were backing away, so they assumed the danger was gone. But that is not the full story. The shocking part is this. In a court filing tied to the ongoing Texas versus ATF fight, the government argued that even though the 2023 brace rule was gone, the federal government could still enforce the underlying short-barreled rifle laws against some braced pistols on a case-by-case basis. That is the move that has people fired up. Let me break this down in plain English. An SBR means short-barreled rifle. Under federal law, that usually means a rifle with a barrel under 16 inches or a rifle under a certain overall length. And when a firearm is treated as an SBR, it falls under the National Firearms Act, often called the NFA. That is the old federal law that brings extra registration rules, extra paperwork, and serious criminal penalties if the government says you violated it. Now here is where the story gets messy. The Biden-era brace rule tried to say many pistols with stabilizing braces should be treated like short-barreled rifles. Courts blasted that rule. Some judges said the agency went too far. One major court ruling vacated the rule nationwide. Other federal courts also signaled the rule was likely illegal. So most gun owners heard that and thought, great, braces are back, end of story. Not so fast. What the Trump DOJ and ATF have done is split the issue into two parts. First, they moved away from defending that old brace rule as written. In April 2025, DOJ and ATF announced they would review the stabilizing brace rule. Then in April 2026, ATF proposed formally rescinding the 2023 brace rule language. That sounds like a win, right? Well, yes and no. Because second, in court, the government also made clear that removing the rule does not automatically mean every braced pistol is untouchable. The argument was basically this. The rule may be gone, but the underlying statute still exists, and ATF can still say some individual braced firearms qualify as short-barreled rifles under the law itself. That is the part that shocked a lot of people. Most people think if a rule gets thrown out, the whole issue disappears. But the truth is a rule and a statute are not the same thing. The rule is the agency's written framework. The statute is the law passed by Congress. If the rule falls, the government may still try to use the statute directly. And if you do not understand that difference, here's what could happen. You see people online saying, the brace rule is dead, so do whatever you want. You believe them. You take your braced pistol to the range, post it online, travel with it, or keep it configured a certain way. Then one day the government decides your setup crosses the line into SBR territory anyway. That is the danger here. This is why this story matters so much. It is not just about politics. It is about whether regular gun owners can clearly tell what is legal and what is not. Here's what most people get wrong. They think this is only about one rule. It is not. It is about whether the federal government can still say, after losing the big rule fight, fine, we'll just do it one gun at a time. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that help gun owners avoid talking themselves into trouble during police encounters. Subscribe so you don't miss it. Now let me explain why this matters in the real world, because this is where it gets personal for you. Imagine you bought a braced pistol years ago. You followed the news, you watched the lawsuits, you heard judges were blocking the rule. Later, you heard the new administration was reviewing it, Then you saw that ATF proposed rescinding the brace rule. So in your mind, the problem is over. That is exactly how many people are thinking right now. But the government's position in court tells a different story. It says, in simple terms, just because the brace rule is gone does not mean we gave up the power to call some brace-equipped firearms short-barreled rifles. Now, this is where it gets interesting. The fight is not just about a piece of plastic attached to a firearm. It is about how much power an agency has to interpret a criminal law, and how clearly the public must be warned before felony charges can happen. That matters because these are not parking tickets. SBR cases can carry major criminal consequences. We are talking about federal charges, huge legal costs, and the possibility of prison. So when rules are vague, normal people can end up trapped between internet rumors and government theory. And let me give you a concrete example from the bigger picture. In one criminal case, Rush versus United States, the DOJ defended the constitutionality of the NFA's registration requirements for short-barreled rifles and argued the Supreme Court should stay out of it. That tells you something important. Even if the brace rule itself gets pulled back, the government has not abandoned the broader legal structure around SBRs. That is the second big thing you need to understand. The Trump DOJ has shown two different faces on this issue. On one hand, it reviewed the brace rule, moved toward repeal, and in another case even dropped an SBR-related charge against Taylor Taranto in 2025 in what the government called the interest of justice. On the other hand, in the Texas versus ATF fight, it still defended the idea that some braced pistols can be prosecuted under the underlying law. So if you are confused, that is normal. The government's own actions are part of why people are confused. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Here's a hypothetical example to explain this. Let's say you own a compact firearm with a brace. You bought it legally. You never filed NFA paperwork because you believed it was a pistol, not an SBR. You read online that the brace rule was vacated nationwide, so you assume you are in the clear forever. But later, a federal agent or prosecutor looks at your exact setup and argues the firearm is really designed to be fired from the shoulder and should be treated as a rifle with a short barrel. Now you are not arguing about politics anymore. You are arguing about your freedom. That is why people are paying such close attention to this case. And here is the part nobody is talking about enough. The big legal fight now is not only, was the brace rule bad? A lot of judges already signaled yes. The next fight is, can the government still reach the same result without that rule? That question is huge, because if the answer is yes, then the battle is not over at all. It just changes shape. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want the facts before the panic starts. Click subscribe and get these updates first. Third, let's talk about why the nationwide angle matters. When courts started striking at the brace rule, people in different states were watching closely because federal law follows you across state lines in ways state gun laws do not. This was never just a Texas issue or just a Fifth Circuit issue in the minds of gun owners. It became a national question because millions of people owned braced pistols, and many of them were trying to figure out whether their firearm was suddenly a regulated NFA item. That is what made the original rule such a huge deal. Then when courts found the rule likely illegal, and one court vacated it, many gun owners thought the federal threat had fully collapsed. But the government's newer filings poured cold water on that idea. They suggested the agencies still believe the statute gives them room to act against at least some firearms with braces. But wait, there's something even more important. A TF also proposed formally removing the brace rule language because courts had found it unlawful and largely unenforceable. That is a major shift. It tells you the agency knows the old rule was in deep trouble. But at the same time, It does not automatically give you a safe harbor for every firearm with a brace attached. That difference is everything. Most people think X, but the truth is Y. Most people think rule gone means problem gone. But the truth is, rule gone may only mean the government has to use a different path. And that is why this move is so shocking. It is not shocking because the government suddenly became anti-gun overnight. It is shocking because it publicly moved toward repeal while still leaving the door open to enforcement. That kind of mixed signal is dangerous. It creates exactly the kind of gray area where regular people make mistakes. Not criminals, not gang members, regular gun owners who believe they are following the law. Have you ever wondered why so many gun cases turn into battles over definitions? This is why. In gun law, the fight is often not over whether you own a firearm. It is over what the government chooses to call that firearm: pistol or rifle, accessory or redesign, brace or stock, legal item or felony trap. And one word change can flip your entire legal status. So what should you do right now? First, do not assume that news about the brace rule means your exact setup is automatically safe. Second, do not rely on social media clips from people who act like one court win solved everything nationwide forever. Third, understand the difference between the brace rule and the NFA statute itself. Fourth, if you own a braced pistol and your legal risk really matters, talk to a qualified firearms attorney before making changes, traveling, or assuming you are protected. Fifth, keep watching the courts, because the next stage of this fight may be less about the old rule and more about direct enforcement under the underlying law. Laws change fast, court positions change quietly, and if you wait until the next prosecution or appellate ruling hits the news, you may already be behind. Subscribe now because my next video will explain exactly what this new DOJ position means for pistol braces, SBR claims, and the mistakes gun owners need to avoid. So here's the bottom line. The Trump DOJ made a shocking move because it stepped back from the Biden-era brace rule, while still signaling that some braced pistols may face SBR enforcement under the National Firearms Act anyway. That means this fight is not over. It has simply moved from one battlefield to another. If this video saved you from believing the easy version of the story, subscribe and share it with one gun owner who thinks rule vacated means case closed. I want this channel to help you stay informed, stay calm, and stay out of legal trouble. And one final reminder in simple terms. This video is for education only, not personal legal advice. If your freedom or your firearm is on the line, talk to a real attorney who knows the law in your situation.